counsel for the respondent, stating that the loan transaction between the parties is amicably settled during the pendency of the present proceedings in full and final satisfaction of all the dues. Hence, nothing survives for consultation. The memo is taken on record, and accordingly, the petition is dismissed as infractious. Yes.
Page number 6, page number 29 to 34.
And for 31, my lord, the date might be given after 22. Seen as having some personal inconvenience, my lord. Matters part heard.
Yes, 31 after 2 weeks.
Page number 7, serial number 34.
My lord, serial number 30, my lord.
Serial number?
Serial number 30. I'm for respondent in this case, my lord. Senior is not well. He is suffering for diabetes.
Inform the petitioner counsel.
Okay, my lord.
Have you informed?
No, my lord.
Wait till the matter reaches. Yes.
Okay, my lord.
Page number 1, for orders matters, serial number 1. Ramana MV.
Do it.
Rama IS.
A week's time for furnishing the process, or else the writ petition should stand dismissed without further reference to the court.
Serial number 2, Panchan Srinivasan.
The petitioner had an interim order on 25/2/2022. So far, the petitioner has not complied with the office objections. What about the notice? What is that? Counsel, respondents are served. No representation on behalf of the petitioner. The list is matter for dismissal. Yes, 3.
Serial number 3. Serial number 3, Vandana PL.
Yes, no representation for dismissal. Yes, 4.
Serial number 4, Omran Khan.
Yes, dismissal.
Serial number 5. Serial number 5, Narayan Swami PM.
The process shall be paid within a week, or else the petition shall stand dismissed.
Serial number 6.
1 minute. No. In the same matter, in respect of R5, as unclaimed, amounts to deemed service of notice. For other respondents, a week's time. Yes.
Yes, no, 1 and 2 are the Union of India. No notice has been ordered. I mean,
In which case, 6.
6. I may permitted to serve a copy on the standing.
Let's see what it is.
And so far R3 is concerned, R3 and 4 are father and son residing on the same address. R4 received the notice and R3 is concerned a return with the correct address. I may permitted to take a fresh notice on the first number 3.
2020, what is this writ petition about?
See, I am a third party.
You have an interim order in this?
No interim order.
Then what is the purpose of?
Purpose is I am a judgment and decree holder. The appeal RFA is pending before this court. The third party has taken a loan and mortgage the property, and the recovery officer initiated proceeding. That was questioned before this recovery officer. Being a third party, the DRT has no jurisdiction to sell the property. My contention was rejected without going into the merits.
So, because there is no stay, what has happened?
My lord, property has already been sold in 2022.
No, already that sales certificate question before this court pending consideration.
Property has been sold in 2022. Against that, so many writ petition and all the writ petition dismissed. And Achil Pachida is in possession, and he has renovated the building and everything. Now the property was sold for 33 crores. bank's due was only 15 crores. Remaining amount is still lying in DRT. That is what he says. Petitioner's interest, he can make an application there if he has got any right to share of the amount that he can get. But property has sold long back.
That
Now
sales.
there is nothing remains
What is
now.
the relief that he is seeking? Let us see.
Now, that relief, my lord, that your lord Mr. kindly say relief.
Lordship, kindly page at 197, order passed by
Call
the.
for records which ultimately resulted in passing the order dated passed in OA number by the DRT Bangalore. And without paying process from 2022, this matter is pending before the court.
No, that's already paid. Your lordship kindly see, so far R3 is returned with correct address. Your R3 and 4 are the same.
Whatever it is, steps have to be taken without service of notice or
I
respondent.
apologize this court.
Well, why should the matter be pending? That means the petition is not interested, and for statistical purposes of the High
No,
Court
so.
and
Your
for
lordship,
West
kindly
Division of the
say- kindly
petition, it is
appreciate this
pending here.
fact. See, so far sale certificate is concerned, I question before this court pending my consideration, and the sale certificate issued colluding with the option.
Petitioner shall pay the, and why the Union of India is a party to this?
Because the recovery officer has passed the order which comes under the Union of India.
Who passed the order?
R2,
Recovery officer of DRT.
DRT.
He rejected the application filed as an objector, stating that if you have got anything and all, you have to go to the court and get the appropriate order. That is what the order passed.
Registrar, Debt Recovery Tribunal, the
That is-
recovery officer too. Now, who has to be served?
R2, Standing Council of the Union of India.
Who is the standing counsel?
Anybody, I will, sir.
Tell the name, we will add order, we will ask them to take notice.
Anupama Hegde.
Anupama Hegde is directed to take notice on behalf of respondent number 2. Land counsel for the petition shall serve the copy of the writ petition on the council. Then what about for fourth respondent?
Fourth already served.
3 has to be served.
Please,
Second time or third time?
this is second time.
Process shall be paid within a week, or else the petition shall stand dismissed against the second respondent.
Please.
Number 7, Rajesh.
My lord, please pay week time to take steps, my lord. For respondent number 2 to
In this matter, my lord, essay is pending before the DRT. My lord, the interim order is not to dispossess the petitioner. My lord, we will not dispossess the petitioner, my lord, till the final disposal of the essay. Because
Yes, ma'am.
2022 matter,
Do that.
we will undertake that, we will not dispossess the
Please.
petitioner.
Directing quashing the notice. What notice? 13-4 notice to be quashed.
And essay is challenging the same essay has been filed before the DRT.
Yes, Mr. Counsel.
this is second notice they have issued, my lord. That I am challenging, my lord. Notice I have challenged before DRT, my lord. That is pending
Why
for,
not second notice for the DRT?
please, my lord. Until disposal of essay, my lord.
The present writ petition is filed. Seek the following prayer. When the matter, then counsel appearing for the respondent, the bank submits that. When a 13-4 notice is issued, the petitioner has assailed the same before the DRT by filing essay number
Diary number 628 of 2021. 28,
620, diary number
diary number
628 of
2021.
628 of 2021. Then why did you issue another 13-4 notice?
My lord, with the 13-4 notice is 28, 2022, same has been challenged before the DRT.
He says it is a second notice.
Notice. And a second
Why
notice
did he-
issued, my lord, 28/22, my lord, second notice. When
First notice is dated?
first notice is, my lord, six one 21, my lord.
My lord, if
6/1.
such being the case, the essay is pending, that essay become infracted.
So why do you issue so many notices like this?
We will issue fresh 13-2 notice, my lord, the 13-4 notice, my lord. We will withdraw this notice. We will reinitiate the measures fresh, my lord, if such being the case.
Essay is pending, my lord. We will prosecute there, my
That
lord.
essay, that notice become infractious.
When the second notice is issued, what will, how can that be? It is as if it is
Yes,
not at all in existence.
When the appeal is
Initially,
pending, my lord,
first notice is issued on 6/1,
2021, my lord.
6/1/2021, questioning the same, assigning in the same, the petition as filed, as approached the DRT, the diary number so and so. Thereafter, the present notice is issued, dated 28/2022. The coordinate bench of this court had passed an interim order on 15/12/2022,
Not to dispossess.
directing the respondent not to dispossess the petition from the scheduled property till the next date of hearing. Then counsel appearing for the bank submits that they will withdraw the notice dated 28/2022
With the liberty to reinitiate.
with the liberty to issue fresh notice under 13(2) or 4.
13(4) of the surface, yeah. 13(2) is,
Under section 13(4) of the Surface Act. It is submitted that in view of the subsequent notice dated 28/2022, the
SCA in
nothing, the earlier notice, the petitioner cannot pursue the earlier notice in diary number so and so. It is also submitted that till then what about not to dispossess?
My lord, till we issue 13(4), we cannot to take the possessions. My lord, after issuance of the 13(4), a fresh cause of action will arise for them to appear.
It is submitted that as they are withdrawing this notice, the bank cannot dispossess the petitioner
Till issue.
till the issuance of 13(4) notice. And once the 13(4) notice is issued, if the petitioner is agreed by that, he can approach the DRT. Next paragraph. Having heard the counsels on either side, there is a material on record, considering the fact that, considering the submission of the land counsel for the bank that they're withdrawing this notice dated 28/2022. The writ petition is disposed of. This court is passing the following order. So the bank is at liberty to issue a fresh notice under section 13(4) of the Surface Act in the light of the fact that they are withdrawing this notice under 28/2022. Till the notice is issued, the respondents cannot dispossess the petitioner. And next, once the 13(4) notice is issued, the petitioner is at liberty to approach the DRT.
My lord, the diary number that may be referenced, my lord, the earlier proceedings has become infructuous.
In view of the second notice issued, the first notice, nothing survives for
In diary number
in diary number. Sorry.
6/28 of 20. Macho.
Seal
Yes,
number
next.
8, MS Chandrasekhar Babu.
Is that?
Lord, advocate for the petitioner, my lord, advocate for the petitioner, my lord, called me and informed some settlement is going on.
There is some settlement is going on, my lord. I request for time.
What is this dismissal of writ petition or otherwise? What is that? Give the order sheet.
My lord, what had happened, my lord, annexure B, my lord, they came before this honorable court on earlier occasion. And in fact, my lord, that order, my lord, this honorable court directed me to, my lord, hand over the possession and pursuant to, my lord, taking some money. That, my lord, I prepared an appeal in.
To be complied with. Why you are not complying with the office objection?
That 25 lakhs has been deposited, my lord.
Office objection.
Office objections is that, my lord, sir. As per the directions of the writ petition, 25 lakhs is to be deposited. We have deposited the same, my lord. And in addition, 5 lakhs deposited.
Let's see, where are the office objections?
That is the appeal petition. It's likely to be settled, my lord. They are in the 1 lakh, 1 crore 5 lakhs. We are in 99 lakhs, my lords. In between, the matter will be settled in 2 weeks, my lords.
Both the fans not. Non-compliance of office objection raised at scrutiny stage.
Please, my lords.
Raised at scrutiny stage.
Scrutiny stage, my lords. That, I'm not.
It's pending till now.
I will do the need.
Please do that. The office objection shall be complied with within a week, or else the writ petition shall stand dismissed without further.
I will do this because settlement is going on, my lords.
Whatever it is, you do
Allah.
what settlement is between you and
Allah.
them. Office objection.
The course of the day, I will do it, my lord. I will do the
granted you
needful.
a week's time.
Weeks time dismissal, you have, my lordship has stated. That's why.
If
That
you
should
don't
not.
comply, then it will be dismissed. If you
Please,
comply, it won't.
I'll do it.
Wait.
Hearing on is the replication, serial number 9. Yes, Venkateshwaran for petitioner.
Yes.
My lord, I am for
Hearing
the
for R1.
petitioner.
Yeah.
The matter has been settled before DRT and earlier occasion petition respondent number participated
Uh,
and respondent number 3 was issued notice to clear the registration of the property.
Is this the matter which I heard earlier?
Yes, Your Honor, yourself.
You want a direction to the third party to execute the sale deed?
No, not that. This matter was, it's my right. They said unless the DRT matter is settled, the respondent number 1 and 3 was waiting for the orders of the state commission. And the state commission is already announced, order has been passed to register this property.
This matter I cannot have, I'm
My
not
lord,
satisfied with the relief
one
that is
second.
sought.
My lord, 1 second. This is a matter which came up before DRT and DRT matter was settled. Subsequently, respondent number 1 has agreed before yourself. And then the respondent 3 was issued notice. So they have to register property. Either
There
give the
cannot
direction,
be direction from this court to a third party to reserve to.
not the third party. Number 1, it is written here, respondent number 1 and 3 will cooperate in registering the property, which is very clear.
Cannot say, that we can't say. That's what I'm trying to say.
I have my rights and under Article 21 and 14.
Want, I can
property
pass
has-
orders on the merits of the matter, if you want. That's the reason why last time I've adjourned it.
The last time your
I'm not
lordship
convinced on that
issued the
point.
notice.
If you want, I can hear the matter.
Yes, Your Honor.
Then I'm making it very clear that I am not inclined to pass any order.
If we have come here for protection of my rights, if the honorable,
Right of every party
not
can't
like-
be protected by the court under
this matter
226.
came up in 2017.
Yes,
and
give the file,
subsequent-
we'll hear the matter. Yes. Yes, argue. Yes,
My lord, my submission is the property to be registered, we have cleared the entire amount. And we have agreed for the state commission orders also to pass on. And they have agreed that they will register property. Respondent number 1 and
who is
3 both.
respondent number 1?
Is the builder.
Now the court in a writ petition will direct the builder to register the property in your favor.
Yes,
That you want the court to pass an order.
yes, yes. Your Honor.
But for that, I'm saying I cannot pass such an order. Court cannot direct the builder in a writ petition to register the
So
property.
this petition came into existence because of the DRT matter. And the respondent number 1 is
Ask the
insisting.
DRT, because if the DRT can has
No,
the
no,
power to do it,
The honorable state commission has ordered already.
then file a contempt if they're not doing before the state commission. For that, a writ petition will not.
So
lie.
my
Please
only
understand.
submission is to adhere to the orders of the honorable
Why
state
should we say
commission.
that? Is it
No,
an executive court?
Your Honor, earlier in the hearing, once the order is passed by the state commission, the honorable court will take it up. That was the order passed.
It is somebody else. If you want, you can move the same judge, but I will not pass that kind of orders. That's not the scope of a writ petition.
No, at least adhere to the
Why should
orders.
we say so? Why should we say so? Please understand. We can't pass such kind of orders. We can't enlarge the scope of a, jurisdiction under
Then
226.
give us some date and
That's why I said, that's why
also
last time also.
interim
that's
order is
what,
maybe extended.
Interim order earlier granted is extended. This is matter after 4 weeks.
Serial number 10.
Lordship, kindly see, this is also
Sureshappa.
matter is going on for settlement negotiation task, please, my lord. Settlement negotiation is task, please, my lord. 1 4 weeks time, you could run it, please, my lord. They are asking for 15 lakhs, we are offer for 10 lakhs.
The 2022 matter, how many days it will be
We
pending?
are continuously touching with the back.
What do you say?
My lord, this interim order, your order may kindly see, my lord, what is the interim order?
Yes. Rupees 5 lakhs within 2 weeks, 5 lakhs within next 2 weeks. Remainder 5 lakhs within 2 weeks. What happened?
Failing which, not only the interim order, interim production shall stand resetted.
Not
but it
complied
will
with.
also have adverse.
So,
Not complied.
Not paid.
Not even a pay.
No, paid 10 lakhs.
How much? 10 lakhs
lakhs,
is
yes.
paid. Another 5 lakhs as per the interim
Not
order
been
not
paid,
paid.
inspect. That is why.
What is outstanding as on today?
As on my law, as on 2/3/2019, 37 lakhs 26,868. At the
It's
time
interest they
of
are claimed, please, madam. This is agricultural loan.
my lord, this
We are giving some concession, please, madam.
concession
That's
and all,
why-
bank and borrower.
You can't abuse the jurisdiction of the court like this
Please,
under, no. The interim order is passed on 31/2022, which reads thus, extracted. Land counsel appearing for the respondent bank submits that the petitioner has paid as per the interim order an amount of rupees 10 lakhs and the remaining 5 lakhs is not paid.
We are ready to
And
pay,
also the
please, madam.
outstanding,
Within 1 week, we are ready to pay the 5 lakhs, please, madam.
not 5, order is on
Please,
31/1/2022. Now you will say that you will
From the
pay.
date of order, we are touch with the bank, we are trying to settle this issue, but they are,
But that is not the interim order. Interim order is to pay the amount.
please, madam.
It is submitted that as on 2019 itself, the outstanding amount is 35 lakhs. How much?
37 lakhs 26,868.
37 lakhs,
26,868.
26,868. The petitioner is enjoying the interim order from 31/1/2022 without even complying the interim order. As per the interim order, if the petitioner fails to comply with the order, not only the interim protection shall stand decided, but will also have adverse reflection on merits of the main matter. The writ petition is filed questioning the warrant of attachment of immovable property dated 2/12/2021 issued by respondent number 1 recovery officer in RC number 277 of 2021 in BOA number 535 of 2020. And also the other relief that is sought is to consider and dispute the application filed in miscellaneous application as per NXJD. The petitioner has failed to comply with the interim order. And also in view of the interim order passed by this court, the bank could not take any steps right from 2022. I'll dismiss this writ petition.
Please, madam, give one short date, please.
The interim, in the light of the same, the interim order granted by this court dated so and so stands vacated. IA number 1 of 2022 for dated, IA number 1 of 2022 is allowed.
Cell number 11. NR Nayak.
Let appear for.
Yes.
I am a tenant. I have participated in bidding. When I am the first person to bid the property, I have also deposited the amount. Then your lordship, I came to know this property belongs to the BDA. Land was acquired long back. This complex has been constructed on the BDA property. Therefore, your lordship, I could not able to get title to the property. Now, your lordship, the BDA has to say whether it is acquired or not. I am depositing rent before DRT as per direction of me.
Let's see, what is the prayer that you are seeking before
Yes.
this court?
To stop recovery of physical possession of scheduled property which is
Stop
subject
recovery
matter.
of the physical portion of the scheduled premises which is subject matter of loan amount. So direct the third and fourth respondent to recover the loan amount by getting other property belong to the second respondent, who is principal borrower, and stop all further proceedings. What is this prayer?
Because your lordship, he is not at all owner. That is the main problem. First respondent being a owner, he has availed loan from the bank. Then your lordship, it is called for auction sale. I am highest bidder. Then your lordship, when I came to know the land has been acquired by the BDA, first respondent ought to have to say whether it is acquired or not. That is only question, your lordship.
Further writ petition is here from 2022.
First respondent is BDA.
For that, why should you file a writ petition? Can't you ask the BDA whether it is acquired or not by under the
Yes,
right to
I
information?
have placed the notification, your lordship.
Then
along
what
with
remains to be
rejoinder.
adjudicated in this writ petition?
Because your lordship now, I am a tenant.
You have paid the money.
Yes.
You want a refund of the amount, or you are seeking some other relief. How can, with this prayer, how your purpose is served?
No, because your lordship now, kindly maybe
How
look.
can we say?
No, bank authority, they are conducting auction sale, your lordship, further.
Please stop, please read your prayer.
Yes.
What is the purpose to be achieved? Read it.
To stop necessary of physical possession of
Not
scheduled
necessary to
property.
stop recovery.
Yes,
Ah.
recovery of physical possession of scheduled property which is subject matter of loan. Amount received by the second respondent by virtue of order passed in so and so. Debt recovery tribunal so and so, which is produced at annexure A, your lordship. That is annexure A, N, your lordship.
Why should we do it?
Because,
How are you entitled for this kind of a relief? Why should we stop? No,
because
it
the
is,
property is not at all belongs to,
then,
now,
then leave it.
now the bank, they have pledged the first respondent.
Enter model in this.
My lord, entry model is there. My lord, kindly come to page number 14 of my statement of objection. There is a mortgage deed wherein, my lord, the borrower respond number 2 acquired the property by way of absolute sale deed dated, my lord, 16/8/2013, which I, my lord, I relied. My lord, kindly come to, my lord, the petition which, my lord, there, my lord, saying that I am unregistered tenant at, my lord, page number 36. My lord, that's 100 rupees stamp paper, not 36, my lord. Page number, my lord, 44. Without my lord, my mortgage, my lord, created by the, my lord, second respondent in the year of 2015.
2015.
My lord, kindly come to, my lord, the document which,
When is this lease?
my lord, he don't have lease, my lord, valid lease at all.
Oh, whatever that alleged.
2015 he is saying, my lord, kindly come to the document which is
I am
produced before the-
depositing rent before DRT as per their direction, your lordship.
My lord, page number 44 of,
As
my
per
lord,
bank direction
One
only
minute,
I am
1 minute.
depositing.
Yes.
page number 44 of, my lord, their petition.
Ah.
They are saying that 16/12/2017,
Page number 14.
44 of their, my lord, petition.
44.
Please, my lord. Unregistered, my lord, document. Nothing is written for, there is no period, nothing. I may permitted to read it. It's in Kannada, my lord. A typed copy also, it's in Kannada. 16/12/2017. For a period of, my lord, not mentioned anything.
For a period of?
Nothing, my lord. They are not mentioned any period.
I'm
Nothing. It's
running
all, my
bar
lord.
here.
It is not even, my lord. My lord, kindly come to, my lord. In fact, the 2017 document, next page number 44, it is taken in 100 rupees stamp paper, not even 100 rupees stamp paper, 200 rupees stamp paper. And, my lord, my mortgage, my lord, kindly come to page number 14 of my statement of objection. Now, my lord, section 14, my lord, assailed before this honorable court. Page number 14, my mortgage.
Your
dated, my
deed
lord,
is dated 3/8.
3 August 2015, before, my lord, their lease, even though, my lord, if their argument is, my lord, they have a bona fide tenant. Before that, my lord, I have a mortgage. And in fact, my lord, original sale deed, my lord, kindly come to the next page. What are the documents submitted before me? Page number 15. The sale deed dated, my lord, 16/8/2013. My lord, respond number 2 is, my lord, he's a, my lord, absolute owner of the property, and he, my lord, on the, by virtue of sale deed dated 2013, he's a owner, and my lord, he created a mortgage in my favor. And, my lord, all along, my lord, section 14 aside. This all the aspect also, my lord, can be assailed before the DRT under section 70.
Yes. Where is the intermodal in this? Give that.
Interim order dated, my lord.
What is she? It's here only.
28/9/2022, my lord.
Stay as prayed for
Houdu.
till the next date of hearing. And that next day has never come.
Lord, we moved many occasions, my lord. In fact, I filed statement of objection in the year of 2024 itself, at 2023 last. I filed early hearing as well as, my lord.
My humble request, my learned friend is not saying that auction sale was conducted. I have participated. I have deposited the amount, but they are now.
If you deposited, that's what I asked
Yes,
you. If you
yes.
deposited the amount and
Yes.
you're asking any relief, the relief that the prayer that you sought has nothing to do with it.
Allah,
You simply say
because
that
what
they're
it
not
happened,
dispossessed.
whether my learned friend say that it is acquired or not, he don't want to say anything.
How will you know?
Yes, I have placed document, your lordship. I have given the document.
I appear for respondent 28.
So now it is, now under the RTA, you ask the court will ask him and you will know from him.
No, your lordship.
You have not sought any relief against them.
Allah, because BD, I came to know when the action sale was conducted. Therefore, I have made
Have
BD as a
otherwise
party.
also.
Allah, I have served copy to them also, your lordship,
My
whether it
instructions
is
are it's an acquired property.
acquired property.
It's a notified, it's an acquired property. My instructions.
Now, whatever are the disputes, whether
Yes.
if it's an acquired property, BDA will fight against the bank. What they will.
Allah, I
settle
am
their
ready to
problem.
purchase the property when they are going to auction sale, your
We will
lordship.
not, that
But now
negotiation,
title is not there, your lordship.
that negotiation we will not do here.
Allah, because the DRT, how can DRT go into acquired property?
Yes,
I am ready to purchase the property in auction sale.
please come.
That is, your lordship, that is the prayer I have sought, because when the
Where did you
owner
start?
himself is not,
Please come to the prayer.
Yes.
Where did you sort that?
stop the proceeding, your lordship, because
I feel-
DRT.
Whose auction? BDA has never conducted auction, my friend is, my senior says, and I never, my lord, it's a section 14 order I said before this one. Whose auction?
You have conducted auction sale, I have participated.
Where is
I have
it?
stated in my writ petition, your
Not,
lord.
you're not stating, where is the document of auction? The notice of auction, where is
I
the
have-
amount that you have paid?
That I have not placed, your lordship.
He
Yes.
came
Because,
only as a
because
tenant.
your lordship, I have ascertained immediately, your lordship, I have,
Please come.
because 25% amount I have deposited with them bank.
Petition is filed, seeking the following prayer. It's a case of the writ petitioner that the land measuring an extent of 5 acre 31 guttas in survey number 38-2 which belongs to one Srimati Chikkamma was acquired by the government by the
Bangalore
BDA,
Development Authority.
by the BDA. Thereafter, subsequent sales have taken place in respect of the said property. The second respondent purchased this property under registered sale deed dated 16/8/2013 from his vendor. The second respondent put up the construction of cellar floor and first floor building and let out the building to various tenants. The second respondent availed the loan from the third respondent bank for a sum of rupees 1,50,00,000 lakhs and he has executed a registered memorandum of deposit of title deeds on 3/8/2015 in favor of the third respondent. It states that the petition is surprised that while looking up the title to the property not verified about the land is acquired in favor of the first respondent and final notification has been issued on 19/1/1994 and the same was published in Karnataka Gazette on 3/1994. This fact was suppressed and loan was granted. It is stated that the second respondent is not ready and willing to pay the installments towards the loan availed by him. Thereafter, the account was declared as NPA and a notice was issued to the second respondent on 4/2/2019. In spite of the same, the second respondent has not come forward to pay the amount. Hence, a symbolic position notice has been issued under section 13. What is this 33?
My lord, 13.4.
Section 34.
13.4 we should symbolic position and section 14 at, my lord.
Section 13(4)
Please, my lord.
of the Surface Act on 10/6/2019. In spite of that, no amount is paid. And then an order was passed under section 40. Or on 1/4/2019. It is a case of the petitioner that he is a tenant of the ground floor premises and taken possession under lease agreement dated 18/3/2015 for a period of 11 months. deposited a sum of rupees 10 lakh as security deposit. Renewal agreement has been made on 16/12/2017. It is the case that he has made huge investments in the premises for running a liquor retail shop with CL2 license. And the third and fourth respondent, bank authorities, trying to forcibly evict the petitioner from the shop. He has made investment in the premises more than 50 lakhs for the cold storage. Declared to come.
Para number 9 I have stated. Auction sale I have participated and
It is stated that as the respondent has failed to pay the amount, they brought, with this you are denying it, Mr. Vignesh.
Please, my lord, I don't have any instruction.
Property has been brought for auction and sale notice issued on 10/6/2009 and fixed a date for auction on 27/2/2019. And he is a successful bidder of the property for a sum of rupees 1,43 lakhs. And he has deposited 25% of the amount. And the bank has called upon the petitioner to pay the balance amount. Petitioner wants to mortgage the property and avail the loan. As this property is acquired with the VDA, he is not able to mortgage the property. The bank has initiated the proceedings by filing OA number 1003 of 2018 to recover the loan amount. In that, another application has been filed with the petitioner in TRC number 352 of 2019. And the order has been passed directing the petitioner to deposit the rent before the tribunal payable to the third respondent by the second respondent. Accordingly, more than 17 lakhs has been deposited before the debt recovery tribunal. During the pendency of the proceeding, the electricity power has been disconnected. And it is also the case of the petitioner that continuously he has been depositing the amount before the DRT. Or it is also been alleged that his signature has been forged and an application has been filed impeding him. It is also stated that for taking the physical portion of the property, an order was passed on 7/9/2022. It is stated that the petitioner has offered one-time settlement of loan amount on behalf of the second respondent, but the third and fourth respondents are not ready and willing to accept the offer made by the petitioner. Even though the property belongs to the first respondent BDA and without initiation or initiation of disposition of the BDA, now the Canara Bank authorities have no authority to take possession of the property. Hence, a petitioner has come before this court. The interim prayer that is sought is to stop recovery of the physical portion of the scheduled premises, which is subject matter of the loan amount. The coordinate bench of this court on 28/9/2022 had granted stay as prayed for till the next date of hearing. The matter has not come up from that day. The bank has filed the vacate petition. Learned counsel appearing for the petitioner submits that he is the tenant, he has participated in the auction, has become the successful, he has already paid the amount. EMD amount was paid. The property is acquired by the BDA, and the BDA, when it is acquired by the BDA, how the bank has granted loan as mortgage the property is not known. And he is a tenant, and he's been in possession of the property and his interest has to be protected. When counsel appearing for the bank submits that his mortgage, the petitioner has no registered lease deed. The lease deed doesn't contain what is the duration. None of the particulars are stated. In fact, the bank has property is mortgaged to the bank on
3rd August 2015.
2015. The bank already an order under section 14 of the Surface Act is passed. Petition, the writ petition as filed before this court is not maintainable. The petitioner, when the proceedings are pending before the DRT, the petitioner ought to have, if at all petition is entitled for any relief, he should have approached the DRT. But with this kind of a relief, the petitioner cannot maintain this writ petition. Next, Learned counsel appearing for the BDA submits that the property is acquired.
Yes.
Now acquired by the
Residential layout. For formation of a residential layout.
For formation of a residential layout, they acquired the property long back in the year 1994.
Yes.
In the year 1994. Then what are you doing when the property is with them?
Let's say the acquisition proceedings have been completed. My instructions are it's an unauthorized construction.
It is submitted that the construction is an unauthorized construction. Having heard the counsels on either side, there is a material on record. Petitioner is a tenant. According to him, the property is acquired by the BDA long back, and without any matter of right and authority, the bank is proceeding with the bank is proceeding under the Surface Act. According to the BDA, it is an unauthorized construction. The proceedings are initiated under the Surface Act. The matter is pending before the DRT. If the petitioner is entitled for any, according to him, he has any right. It is the case of the petitioner that he is ready to settle the entire amount on the one-time settlement. And at one stretch, he says that he is ready to settle the entire amount, and that on the other stretch, it is stated that the bank has no authority. If bank has no right over the property, why he is coming forward to pay the amount is not known. It appears that as a petitioner is running a bar with CL2 license, the petitioner wants to retain the property, and in that process, a writ petition is filed before the court. Looking at the prayer that is sought, this court cannot grant any prayer, and they grant the prayer as sought for by the petitioner. If the BDA, according to the BDA, if it is their property, it is for the BDA to take appropriate steps. And now the bank has initiated the proceedings under the Surface Act. If required, the BDA can as well contest before the tribunal, even if the petitioner feels that he has any legal right, he as well can contest the same before the DRT. The learned counsel appearing for the respondent bank submits that as submitted by the petitioner about the auction notice and the auction being conducted. In the vacate petition, they have not stated, he has no instructions.
No instruction, in fact, my lord, 2019 auction conducted. Even though he paid 25% of the money, by this time they, my lord, however, I don't have instruction. In
That's
fact,
what I say.
Please.
That he has no instructions in that regard, be that as it may. The petitioner cannot approach this court with the reliefs as sought before this court. And accordingly, this court is passing the following order. The writ petition is disposed of, giving liberty to avail the appropriate remedy, if any.
My humble request. Till then, because license is renewed time to time.
Maximum 4 weeks, not more than that. For a period of 4 weeks, the bank cannot.
For
interfere.
vacate is concerned, your lordship, I will fight before the.
That's what, for 4 weeks, the bank shall not interfere with the position of the petitioner.
Please.
Yes.
Case number 12, preliminary hearing, Rajendra MA for petitioner.
Appearing for petitioner, Your Lordship. Your Lordship, there is no instruction from the client. There is no instruction from the client. We are retiring from the case. But like the WP was filed on IA of SA 417. Now the SA is also dismissed.
No, I didn't get you. What is that?
We don't. First of all, we don't have any instruction from the client. We are retiring from the case.
Oh, you have no right.
We are retiring from the case. We don't have any instructions from the client. He did not approach again with us.
Where did you file your retirement memo?
I still did not file.
You are seeking time.
Yeah. I'll file retirement memo.
This is matter next week. It is submitted that the petitioner has no instructions and they are going to file the retirement memo. This is a matter next week.
Cell number 13, Omar Nasiruddin.
Okay, for the petition in this case, Lord.
Yes.
Lord, the scheduled property was purchased by my mother and she was, came to me as a registered will.
Let's look at the prayer that is sought.
Interim prayer, we have sought for the grant of stay. Further proceeding against me, that is, I'm the fourth defendant.
No, let's see the prayer. Where is it? Which prayer, page is the prayer?
At 13, my lord, ink page 13.
13 is a interim prayer you are seeking.
Prayer and
Prayer,
interim prayer, both are there itself.
Call for the records in original application number and set aside the order dated and allow the application fixed by the petitioner before the tribunal. What is that order?
Which is at annexure A, my lord.
So far, notice is not ordered in this matter.
No, my lord. No.
So that means you are not interested to pursue this
No,
matter?
not like that. But after that, I think, if I'm not wrong, in the last time, I think this is the second time it has been came before this.
So that, so no interim order, nothing.
What has happened in this one is, I have let out 2 shops for the tenants.
Grant order, though by virtue of the orders passed by the DRT in the OA,
Yes,
the bank must have taken steps. Which bank is this?
Indian Overseas Bank.
Hmm?
Indian Overseas Bank. IOB.
Overseas bank.
Bank of Baroda.
Yes.
Who appears for Bank of Baroda?
That
Vignesh Shetty appears? You appear? Yes. So and so is directed to write the name. So and so is directed to take notice on behalf of the bank. Petition should serve the copy, serve on him.
Yes.
Serve the copy of the writ petition on the council. List this matter after 2 weeks.
cell number 14, Niladhar HP for petitioner Francis Xavier.
And for the respondent in this matter.
Switch on
In this case, you issued a letter
the, now open the,
that one
now it is little something.
entire amount shall be settled within March 26.
I'll give
And we are expecting the communication from them.
Huh?
Not in
Want
this-
to settle the matter within March 26, entire amount. We have communicated, they have officially communicated, so 1 week or 10 days may be given.
Same thing last time also.
My lord, in this matter, my lord, their prayer has been rejected. We are in the process of communicating to the borrower. for rejection of the
One-time settlement.
one-time settlement. 1 crore 75 lakhs they requested, that took up to March. That management has rejected, my lord, committee has
No
rejected.
communication has been given. till
We
date.
are in the process of communicating, rejected. As far as the possession notice is concerned, my lord, the interim order was passed on 12/7/2024. 35 lakhs,
Paid?
not yet paid. Even lapse of
Then
1
we
year,
do
my lord,
something, you communicate,
Yes, ma'am.
interim order not complied, we will vacate the interim order.
direct them to approach the DRT, my lord, if such being the
Let them
agreed by the
communicate
measures
the
initiated
RT.
under.
Let them communicate the RT. They themselves have.
That
I'm
is-
not disputing.
My
Please listen to the court. I'm not dismissing the writ petition. Writ petition will be pending. Interim order you have not complied
Yes,
with.
that's-
That I will record and I'll vacate the
Please,
interim
please,
order.
please.
My lord, in this
Uh,
case, my lord, the prayer is not for OTS. The prayer is to set aside the possession notice issued under section 34 of the
Now,
service here.
when is this writ petition of
2024.
So communicate it to him.
Yes,
He
we will
whatever-
communicate.
Then, no, when the interim order is vacated, you can't have any problem.
Yes, my lord.
Where is interim order? Dated?
12/7/2024.
1/7.
1/7. 12/7.
Head office has been agreed.
I have instructions.
12/7, there is no order like 12/7.
My lord, sorry, my lord, this is 10/6/2020.
Huh.
10/6.
On 10/6/2025, a coordinate
Yes,
bench of this
24,
court. 24, a coordinate bench of this court has granted an interim order subject to the condition that the petitioner shall deposit rupees 35 lakhs to the respondent on or before 12/7/2024. Land counsel for the petitioner submits that land counsel for the petitioner submits that the one time they want to pay the entire amount, and it also going, they have already made they have requested the respondents for a one-time settlement. Land counsel appearing for the respondent bank submits that the interim order dated 10/6/2024 is not complied with, comma, the bank has already rejected the one-time settlement, the representation.
Entire amount.
for-
Entire amount.
The entire amount is
Bank
2
has
crore.
rejected the petitioner's request and they are in the process of communicating the same to the petitioner. Next para. There is no dispute about the fact that the interim order dated 10/6/2024 is not complied with by the petitioner. Hence, the order dated 10/6/2024 is vacated.
Much,
This is matter after 4 weeks.
much of.
Cell number 15, Sajib, KR petitioner Vignesh Shetty.
Respondent my lord, subsequent to this writ petition, they have already approached DRT, my lord, and obtained interim order. Yesterday, one writ petition also they filed, my lord, challenging that DRT interim order, and the matter got disposed by paying 25 lakhs of DD.
So nothing remains in this.
Yes.
What is the? The prayer is to quash the order dated 21/8/2025 passed by the Metropolitan Magistrate. That is 14 order is questioned. What is that you filed in your vacate, that order?
My lord, in this, no interim order, my lord, in this matter, no interim order.
No, you filed your objections, I think.
No, my lord, we filed a memo for producing a document.
Let's see,
of
let us
that-
see what are those.
In previous occasion, they made submissions that.
Where do you get that number, OA, with regard to section 14? Please give those numbers.
Essay number,
Huh.
diary number, man.
Huh?
3311 of 20.
1 minute. Essay number,
Diary number, man.
diary number,
3311 of 2025.
3311 of
2025.
questioning section 14.
Please, man.
Huh?
They got some interim.
When is the
order.
interim order passed?
Few minutes, man.
Oh. I'll call the next matter, write the details on a paper and give, call the next matter.
Cell number 16, PC Avinash.
Lord, I requested my friend to provide one set of copy. You provided, my lord, we
Which matter?
misplaced 60. And 1 week time may be given, we will file our statement of objection in this matter.
Date may be fixed
The list is matter
on 20th.
on
20th.
20th or 21st. We'll
on
file out.
21st.
Much.
At the request of land council for the respondent.
Respondent.
Notice to respondent number 2 to 5 may be dispensed with.
Have you filed the memo?
I'll file a memo now.
Memo is filed seeking dispensation of notice to respondent,
2 to 5.
2 to 5 dispense with at the risk of the petitioner.
Much.
Much.
Cell number 17.
My lord, I appear for the respondent bank, my lord, in serial number
Yes.
17. My lord, the prayer in the writ petition, my lord, is not maintainable. At page 13, please, my lord.
Page
Page 13, please.
1-3.
Please, my lord. What is challenged is, my lord, vacation notice issued by me. And my lord, the act specifically says, my lord, what they can challenge is either the 13th.
Writ of Sarishwari to quash the mortgage property vacation notice.
Vacation notice cannot be challenged, my lord. The act permits only challenge of section 14 order or, my lord, section 13(4) notice, my lord.
Mm.
My lord,
And under which provision you have given this?
Lord, we have intimated them that we have got an order from the learned magistrate. So you please vacate, my lord. My lord, if your lordship please, my lord, the writ petition is filed on 7/11/2025. And till now, my lord, they are not appearing.
Close it, it's very cold.
In fact, due to the pendency
No,
of the writ petition,
that's
we
what I'm asking. That's what I'm asking. You have given this notice.
please.
Under which provision you have given that?
Lord, there is no necessity to give this notice. In fact, under the act, my lord, there is no necessity. But, my lord, because there are residents, my lord, we inform them that such an order has been obtained by us. Please vacate the premises, my lord. That is giving time for them, my lord. And in fact, 7/11 they filed this writ petition. They have not appeared, my lord, on 2 occasions.
And what is the position now?
My lord, we have not proceeded because there is this matter is pending, my lord. There is no
interim order.
There is no interim
Even
order.
if there is no interim order, you will not proceed with the writ petition is
We have
filed.
not proceeded, my lord, because, my lord, some residents are there. I just wanted to bring it to your lordship's notice, my lord. This is the present situation.
Please come. There is no representation on behalf of the present writ petition is filed. Seeking the following prayer. There is no representation on behalf of the petitioner. When counsel appearing for the petitioner submits that either an order is passed under section 14 and thereafter they've issued a impure notice dated 4/11/2025, that is styled as mortgage property vacation notice. It is submitted that there is no provision under though there is no provision and the notice is issued by the bank communicating to the petitioner. If the petitioner is aggrieved by an order passed under section 14, he can question the same or the notice under section 13(4), but not a notice that is issued, but not the notice impugned that is dated 4/11/2025. It is submitted that no interim order is passed in this writ petition and the writ petition is pending on 2020. Writ petition is filed on
7/25.
7th
On November 2025.
25. This matter? 7/11/25. Considering the submission of the petitioner, this court is passing the following order. The writ petition is, if the petition is disposed of, giving liberty to the petitioner
Please.
to question an order that's passed under section 14 of the Surface Act.
Obliged.
If it is in accordance, if it is within limitation and in accordance with law. Yes, next.
Cell number
And the
20.
bank is permitted to proceed further.
Huh?
Bank
No,
will
not, petition is dismissed.
obliged.
Yes.
18 and 19 urgent. Cell number 20.
18 and 19, they sought for adjournment.
19 does not survive, madam.
What happened in 19?
19, the interim order granted by the Garnicia order granted by the DRT is under challenge. Today that OA itself is posted for judgment today.
What is the date given?
That is next week. Interim order next week.
Yes, next.
Still number 20, Vandana PL.
For respondent. This, Your Honor, my lord, the petition not maintainable because the essay is pending before the DRT.
On the same.
Stay, interim stay is there in this.
No, what is impugn
And for
here?
the petitioner, my lords, all the payments has been done, my lord. Will produce the,
No, please wait. What is the writ petition about? Let's see the prayer. What have you questioned? Admit the present writ petition despite the alternative remedy available under. What is this prayer?
This prayer, their alternate remedies they are seeking
No,
before
no,
this.
they say that admit the present writ petition
Yes,
despite
yes,
the
please.
alternative remedy and also and so.
Absolutely. Since the essay is
It
pending
is
before
pending
the.
in essay number
Yes,
so and
one.
so. Issue a suitable writ or direction like in attempting to proceed against a petition and the scheduled property and the Surface Act. When you yourself admit that your essay is pending before the tribunal, you should seek the relief from the tribunal. Why should you file a writ petition here?
my lords, my humble submission is this, my lords. I am a proxy counsel, my lords. I have instruction regarding this.
Yes, list this matter on Tuesday.
Grateful, my lords.
It is submitted that it is submitted by the land council appearing for the respondent bank that the petition has initiated the proceeding before the debt recovery tribunal and has come before this court seeking stay of disposition.
Yes, yes, please.
Stay of disposition and the petition is not maintainable. The proxy counsel seeks time. List this matter on Tuesday.
Grateful.
31. Serial number 21. Serial number 21.
Lordship, in this matter, settlement is going on.
Rajendra.
Two properties has already been settled.
Without even notice is served to the bank. Which bank
Yes,
is this?
Lordship,
That is
State Bank of India, who appears? Mr.
State
Vignesh
Bank of-
Shetty is directed to take notice on behalf of the respondent bank. Land counsel for the petitioner shall serve the copy of the writ petition. This is matter after 2 weeks. Yes, 22.
Number 22. Kiran J. Shetty and Hegde.
My lord, kindly have it on the next week, my lord.
On?
Kindly have in the next week, my lord.
My lords, writ petition is not maintainable.
Let's see.
All property sales certificate has been registered, my lords.
Good. Let's
In the year of 2023 only, my lords. There are 3 properties, my lords.
Let's see. The operation of the alleged order dated passed by the, section 14 is questioned.
Yes, my lords.
After that, what happened?
They filed essay, my lords.
Questioning the very same.
DRT.
Questioning the very same.
Yes, same, my lords.
What is essay number?
Essay number
262 of
262 of 2022.
262 of?
2022.
And then what happened to the essay?
My lord, the Tenant tribunal was pleased to grant ex parte order, my lord, pursuant to that.
They have
And
not
we-
completed that order, my lords.
My lord, I'll seek instruction.
No instruction. Please come. The present writ petition is filed, seeking the following
Lord,
prayer.
kindly have it, I'll just, at least
It
on
is an
Monday, my lord.
admitted fact that the petitioner has filed essay number 262 of 2022 before the DRT. It is a submission of the land counsel for the respondent that the court has passed an interim order which is not complied with by the petitioner. When the petitioner has already availed the remedy, alternative remedy, the present writ petition before this court is not maintainable. Accordingly, the writ petition is disposed of, giving liberty to the petitioner to pursue the essay that is pending before the DRT.
Serial number 23. M. Chandrasekhar.
Yes,
Nagar Damodar for respondent.
Appearing for the petitioner.
Yes.
And the petitioners are being then agriculturists, they mortgaged.
Let us see the prayer.
Please. Issue a writ in the nature of certiorari quashing the action sale paper publication dated 11/5/2022 and same was published on so
So
and
you have
so.
questioned the auction sale notice.
Yes, madam, without issuing the personal notice and the sale notice is against the dead person and the amount is fixed for 20 lakhs.
Have an interim order in this?
Correct?
You have an interim order in this?
Yes, I complied the interim order also.
No representation on behalf of the respondents. Interim order earlier granted stands extended till the next date of hearing. List this matter after in the month of March.
Please.
Case 24.
24, Rajendra MA. Tulsi Kumar.
Matter has been settled.
Yes.
Appearing for the
Matter,
respondent.
when the matter has been settled.
Huh?
Settled, it's
Matter
settlement.
settled?
My lordship, they have gone for the challenging the DRT dismissal of the order. It should be moved on to the DR80.
According to you, what is
The
settlement?
matter is settled, your lordship. The
Where?
payment
How?
has been done outside court.
The account is-
Outside the court.
My lordship, according to the bank, we have not
Anyhow,
given.
on that he wants to close the writ petition, so you can't have any problem. Land counsel appearing for the petition submits
The
that
account is not closed, my lordship. My lordship, the account is not closed as per today.
No, please understand. That is his writ petition. He says it is closed.
Okay.
So you can't have any
Okay,
problem.
grateful.
Land counsel with the petition submits that the dispute, it submits that the dispute is settled outside. So the dispute is settled and nothing survives for consideration in this writ petition. Give a memo. Write a memo and give.
Sure.
It is a memo is filed stating that the dispute between the petitioner and the bank is resolved out of the court and nothing survives for consideration, accordingly dismissed as withdrawn. Yes, 25?
Cell number 25. Cell number 25.
Yes.
Hiramatan.
My lord, your lords may kindly see the order, my lord, in this. On 22/11/2022.
22?
22/11/2022, this order of this.
When counsel appearing the petitioner would restrict his submission to a direction to respond on a bank to divulge the sale details of the property belonging to the petitioner that has allegedly been sold by respondent number 1 bank. Therefore, the land counsel is directed to accept notice.
Yes, my lord, that the bank has informed long back that they have disclosed exactly what is that sale.
Let's see, the land would restrict his submission to a direction to respondent number bank. What is
To
the?
divulge the sale.
Let's see the prayer.
Prayer is page number 8 of the writ petition.
Page number?
8 of the writ petition.
Yes.
Wherefore, the petitioner is respectfully pray that to issue the writ of mandamus by directing the respondent to furnish the detail of the loan and recovery proceedings thereon, including sale by way of action conducted, and kindly issue the writ of certiorari by quashing the proceedings of.
No, the second prayer he is not asking.
No, my lord, there is not, prayer is this much only to divulge the information.
That's what I'm saying. He says, no, there are two prayers. One is for the information, second is to quash OA number so and so. Now he is restricting his prayer only to one.
One. It has been done, my.
You have already given the details.
Details has already given, that is on 22 only. But
The present writ petition is filed seeking the following prayer. When the matter came up on 22/11/2022, this court has, the coordinate bench of this court has passed the following order, extract the order. Land counsel, there is no representation on behalf of the petitioner. Land counsel appearing for the respondent bank submits that as per the order passed, as per the interim order dated 22/11/2022, they have already given the information to the petitioner. Hence, nothing survives for consideration in this writ petition. Next para, having heard the land counsel, the respondent peruse the order dated 22/11/22 and the prayer that is sought in the writ petition. In the light of the order dated 22/11/2022, and as the respondents have already given the information, nothing survives for consideration in this writ petition, accordingly dismissed as instructed.
Cell number 26, Lokesh MY. C. Vinay Swami.
So the respondent, as the matter is settled, the loan accounts are closed.
Closed.
Yes.
Land counsel appearing for the reserve. When the matter came up for hearing, there is no representation on behalf of the respondent or petitioner. Land counsel appearing for the respondent submits that the dispute is settled and the loan account is
It's closed on 31st of January 2025.
31st January
2025 under OTS.
Under OTS. Considering the same, nothing survives for consideration in this writ petition, accordingly dismissed as instructions.
Cell number 27, dispose 28 urgent. Cell number 29. 29, Arun Govindraj.
Lord, I appear for the petitioner.
Yes.
Lord, your lordship had passed an interim order in December directing the husband to pay 1 lakh within a day and then 10 lakhs within 2 weeks. Lord, the 1 lakh he has complied with, but unfortunately the 10 lakhs he has not. I have sent him an intimation that I would like to retire from the case. Lord, if the lordship calls this matter next week, I will produce the acknowledgement and then I will file my memo of retirement.
Your lordship shall pay an amount of rupees 1 lakh to the respondent by 16/12. The
That
account
he has
details. which the husband shall pay an amount of rupees 10 lakh towards part of the outstanding amount within a period of 2 weeks from today.
Yes, that he has not complied with, Lord.
Your Lordship, 3 dilutions have happened. One is that 50,000 each, which the lower court ordered. The coordinate bench said, at least let's make it 50 for now. You deposit that. That also has not been complied with. Then your Lordship, in the interest of trying to settle the matter, had only further stayed. Otherwise, there was no question of staying. Since that also did not work out, then they further came up, and then after all the calculations, your Lordship, now your Lordship had further diluted it, saying, all right, at least till I hear the matter, at least pay 10 lakhs for now. Even that has not been complied. This is not even a situation where these people can't afford. They're worth over 1,500 crores. And now the latest is that they will retire from the case. Now, your Lordship, even if they're...
Arungovindraj, as
Yes,
he has
yes.
not, yes, he has not complied with the interim order, I'll record it and I'll vacate the
Vacate,
interim order.
please.
My Lord, may also record my submission that I wish to retire from the
please.
case, and I file my
Yes,
memo
Please.
along with the other.
When the matter came up today, when counsel appearing for the petitioner submits that the order dated 15/12/2025 is is partly complied with as far as the amount of rupees 1 lakh is concerned, that is paid by the petitioner, and the remaining amount of 10 lakhs towards part of the outstanding amount, which is directed to be paid within 2 weeks from the date of the order, was not complied with. It is submitted that he is going to file the retirement memo. Land counsel for the respondent, the land senior counsel appearing for the respondent submits that the petitioner, on one pretext or the petitioner has failed to comply with the order, and on various reasons the matter has being the court has granted the interim order, and financially it is not the case that they're not in a position to pay, and they're in the earlier order also on the last in the earlier hearings, it was argued about the financial capacity of the husband. Next para. When this court has directed, heard the parties and passed an order dated 15/12/2025, directing the petitioner to pay 1 lakh by 16/12, and within 2 weeks, an amount of rupees 10 lakh, the petitioner has failed to comply with the order passed by the court. Hence, the interim order granted, on which date it is granted?
Your Lordship, this is on 9/4/2025 was the first order.
9/4/2025 is vacated.
In fact, in that, it was actually a conditional order. It was only upon the condition that they comply would the interim order stand.
Yes, it's
Please.
vacated.
Please.
Yes, next.
Your Lordship, that 31/7 order of your Lordship, that we don't take coercive steps, if that could also be vacated.
Both 31?
31/7, 2025 and 9/4.
That order also, and so it
Please.
stands vacated. Yes.
Please, obliged. Lordship, any date for final hearing since this is part
This is a
of,
matter in the month of March.
please, obliged.
Till number 30, Syed Khalil Pasha,
This case.
A. Gangadhar.
Respondent argues the matter.
And for respondent in this case, my lord, senior is not well, my lord. She is suffering from diabetes, my lord. First time for 2 weeks, my lord.
List is
Interim
matter.
order may be exchanged. Interim order may be exchanged.
List is matter after 2 weeks interim order earlier granted is extended till then.
Till number 31, adjourned.
Much of
Till number
my
32, Likit. Are we respondent?
Yes.
Respondent.
Respondent.
Yes.
On 22/9, your lordships had heard this matter, my lords. This is a matter relating to challenging the order allowing the application under order 6 rule 17.
Is it a part-word matter?
Yes, my lords. Please. The respondent herein, who is the petitioner in the
1
MC.
minute, 1 minute.
Please.
Yes.
The respondent herein, who is the petitioner in the MC case, matrimonial case, my lords, filed an application.
Wife or the husband?
I am the wife. At page,
File the MC.
The
Husband
respondent,
has filed the MC.
husband has filed the MC. At page 54, my lords, an IA came to be filed for, at page 54,
Mm,
that is IA number 12, my lords.
mm.
That was filed under order 6 rule 17 seeking amendment of the cause of action at the stage when the matter was posted for final arguments.
Mm.
My lords, the same set of facts was already brought on record by order dated, my lords.
What is that he wants to add?
That's
by
a
this?
subsequent event that had taken place after filing of the MC case, my lords. That
Be part of the cause of action.
should be part of cause of action, that was. But that event had taken place in the year 2018. my lords.
When was the MC filed?
MC was filed in the year 2017.
2000. Let's look at the affidavit.
Please. my lords.
Yes, please read the affidavit.
Lords, it says, I states that I filed the petition against the respondent. My lords, I'm at page 55. my lords. I state that I filed the petition against the respondent for seeking of decree of divorce. The above matter is posted for arguments. The petitioner has led his evidence by filing all the evidence available documents. The Honorable Court has marked the FIR charge sheet which is filed against the respondent and others during the examination in chief. Unfortunately, the amended petition was filed without mentioning the said incidents in the cause of action, para number 10. In this regard, the fact about the incident has mentioned in the 6A para of the main petition. It was already introduced. The petitioner, in spite of due diligence, could not raise the matter before the commencement of trial in regard to the cause of action. Hence, it's very pertinent to mention in the paragraph of the cause of action, the crime committed against the petitioner and the cause of action of the FIR and the charge sheet in the 10th paragraph cause of action in the main petition. It's very main core of contention of the petition to prove my case, mentioning the facts and reasons.
You say that it has happened subsequent to filing, but it doesn't say so. According to them, it is before filing.
No, my lords. My lords, they are relying on, my lords, I'll take your lordships to annexure A.
Page number?
At page, my lords. Annexure B, my lords, at page 26.
Yes.
That is the complaint which
This
was.
is dated 5/12/2017.
Yes, my lords, this is the fact which they are wanting to introduce as a cause of action.
No.
My lords.
MC is filed when?
My lords, MC is filed, my lords, on 15th November 2017.
So this is subsequent to that.
This incident is subsequent to that.
So tell one thing, what is the prejudice that would be caused to you now?
My lords, it is already introduced. In the year 2018 itself, an amendment application was filed. Para 6A was introduced, narrating all these facts. Now they are intending to alter the cause of action.
Please come to the impugned order now. Where is the impugned order?
At page, my lords, 106 minutes.
Page number?
Page number 106 minutes.
Please read.
This is an application filed by the advocate for the petitioner under 6 rule 17, read with 151, to permit the petitioner to amend the petition by substituting sentence in the cause of action as mentioned in the application, which is read as under.
What is the stage of the proceedings?
Final arguments.
When it is listed for final arguments?
Yes. It was for final arguments. And all this content was requested for substitution.
Come to the point.
And also the cause of action arises when the petitioner was beaten and harassed physically and mentally by the
So
respondent.
please come to the reasoning part from going
Yes.
through the proceedings.
That's reasons, my lords, at page 108, point number 1. From going through the proceedings in this case, it is clear that on 13/7/2018, the present petitioner has filed IA number 3 under order 6 rule 17, read with 151, seeking permission to amend the petition. Along with the amendment application, he has produced the documents and the case was posted for objection on 8/8 so and so date. On 22/9/2018, the application came to be allowed by observing that the proposed amendment is to narrate the subsequent event. If the amendment application is allowed, no prejudice would be caused to the respondent, as she will have an opportunity to meet the case of the petitioner by filing addition, objection and cross-examining the petitioner and his witness. Thereafter, the petitioner has got amended the petition and he inserted para 6A in the petition. As per para 6A.
Now this application is allowed. What would follow?
My lords, the cause of action would be amended.
It
The
is,
petition, my lords, is lacking cause of action. That is the main contention.
what is that?
It is lacking cause of action. There is no cause of
So
action.
he
for-
wants to, whatever the
Introduce.
lacuna that is in the.
Yes, my lords. Why? Because, my lords,
What
in the
was
cross,
what was the earlier cause of action? Let's see.
nothing. I'll take a lords.
Where is the petition?
Petition is at page, my lords, at page, as annexure A, page 17, my lords. May kindly see the cause of action. At page, at page 23, my lords, paragraph 10.
Hmm.
My lords, by troubling your lordships, I just read the heading of this one petition. It says memorandum of petition under section 13(1) at page 17, my lords. I'm sorry, my lords. At page 17. Memorandum of petition under section 13, subsection 1, small clause 1 and 1A of the Hindu Marriage Act 1955. I take your lordships to page 23, my lords.
Yes.
Paragraph 10. It is submitted that the cause of action for this petitioner arose on when the respondent withdrew from cohabitation with petitioner and started physical and mental harassment towards him, and when the petitioner and his family called the respondent to file criminal case, and when the petitioner living separately since 2011, and it continues till the date of this petition. Nothing has been proved. The trial is almost completed. It was posted for arguments, final arguments. When I was cross-examining the respondent, there was one aspect which he spelled out. That is, my lords, in the cross-examination, he said that he filed this complaint only because we did not settle the divorce case. That is the only reason he is come up with this application. I'll bring your lordships. I'm sorry, my lords, that actually the cross-examination is in Kannada, my lords. If your lordships permit me, I will submit a translated copy, my lords. He says
You can
only
read
because.
Yeah. You can read. Yes.
He says only because the divorce was not settled and we did not agree to provide, agree with for the divorce petition. He filed the FIR. That is what was spelled out in the cross-examination. Later on, he came up with this application when he came to know that there was no.
When is the case posted for arguments?
That's the order sheet. Is at page.
No, the first amendment was on 1610.
Yes, ma'am. In the year 2018 itself, it was amended.
16/10/2024, the first amendment.
No, minutes. I'm sorry, minutes. It is on 22/9/2018.
22/9?
2018. The
Where
same
now the facts are stated in 2019.
18.
18.
Yes.
And the cause of action now they want it in 2024.
24.
To substantiate that.
Yes. They only want to seek the amendment of the cause of action. Introduce a cause of action, which they didn't have. That is my case.
What is?
And that too at this stage of final arguments.
Kindly see page number 109, my lord, paragraph 8, my lord.
109?
9, my lord. That observation, the trial court, my lord.
No, why should you, how many times you will do this?
My lord, kindly, this is very important, my lord. I'll read this one, because
Read.
thereafter, my lord, kindly paragraph. Thereafter, the petitioner has got amended the petition inserted 6A of the petition. As per 6A of the petition, it is a specific case with the reference to the incident happened on 5/12/2017 at about 7 PM. And the case was registered so and so IPC. He produced the FIR. From going through the evidence reduced by in the case, it is clear that already said FIR is marked at Exhibit P3.
Definitely, that cannot be termed as a cause of action because this has taken place after you have filed the petition. Cause of action is something, okay, if you want to, get all those facts on record, it is a different aspect.
2 minutes.
You can't call it a cause of action. Cause of action is something which is available to you as on the day when you're filing the petition.
Because there are two cause of, because my lord, cause of action.
You cannot call it as a cause of action at all, that FIR.
Because my
FIR
lord,
is subsequent.
on the ground of cruelty, my lord, it is the cause of action, my lord. On the ground of cruelty, my lord, it is the cause of action, my lord, because petition is filed under section, under section 13(1)(a) and 13(1)(a) on the ground of cruelty, my lord.
Please understand. You want to get certain facts on record, the
True,
court can understand, and court has already allowed your application under order 6 to 17. That's over. Now, cause of action is when you are filing the petition as on the day in the year 2017, whatever is the cause of action that you have to say. Now, a subsequent action cannot be a cause of action.
The subsequent action can be cause of action, my lord. That is the observation of the Lord Supreme Court, my lord. Kindly see that paragraph 9, my lord. Paragraph 9, my lord, relying that one amendment, please. Paragraph 9, my lord.
Please read.
The learned advocate for the petitioner in support of the argument as regards so and so. Civil procedure. Order 6, Rule 70. Amendment of pleading. Role of court. Principle of applied. All amendment to be allowed. Amendment shall not cause prejudice to the other side, which cannot be compensated by the cost. Amendment after statutory period discussed as ultimately that the amendment should be allowed. From going to the judgment, it is clear that if amendment is showing the cause action, other side will not.
No, you have not answered my query. That is not there in this judgment. I said cause of action as on that day.
Right.
Facts, it's a different aspect. Whether the facts have to be on record or not, court has exercised the discretion and allowed the earlier application. When it comes to cause of action, you can't plead a subsequent event as a cause of action to file a MC at a prior date.
Prior date, my lord, because I included the prior date, my lord. Subsequently, my lord, amendment also carried out, my lord. Kindly see.
No, that is a different aspect. You wanted that to be on record to further show the conduct of the party, that the court has done it, he has not questioned it, it's fine. It can't be a cause of action.
My submission is that, my lord, page number, that is the cause of action, because, my lord, on the ground of cruelty, my lord, it was filed, my lord. That is the reason, my lord. That is the.
What I'm saying.
True, my lord. Correct.
You have filed the MC on January.
2017, my lord.
Let's say January you have filed. In the month of January you have filed. Certain things happen in the month of February. You want to keep all these issues on record. You filed an amendment petition for the pleadings. That court allowed. But cause of action will not be at a subsequent date. It would be the reason for you to come before the court. Please come.
And moreover, my lord, kindly see that, my lord, page number 102, my lord. Already amendment is also carried out, my lord, in this case. Kindly see that, my lord, page number 112, my lord.
But the court can't do it. Please come. The present writ petition is filed.
I'm sorry.
Where is the order?
The lordships permit me, then I can file some certain citations.
Not required.
Please.
Where is that?
Please.
Where is the interim of this page number impugned order?
Impugned order is at page
106
106 minutes.
The present writ petition is filed, questioning an order. What is the number of the IA?
IA number 12 minutes.
Questioning an order that's passed in I number 12 in MC number 5648 of 2017, dated 16/10/2025, whereby the court has allowed the application that is filed by the husband. The parties are referred to as wife and husband for the sake of convenience. The respondent husband had filed the MC 5648 of 2017 seeking divorce on the ground of cruelty. Earlier on 29/2018, the court has allowed an IA that's filed under order 6 rule 17 seeking amendment of the pleadings, where the respondent wanted to bring on the respondent wanted to amend the pleadings with regard to a cause of action that had taken place subsequent to filing of the petition. The same was allowed, and the petitioner and the respondent husband has brought on record all the FIR and other particulars. Thereafter, the trial has commenced, and after the trial was concluded, and the matter is posted for arguments, at that point of time, the petitioner has, the respondent husband has come up with this application under order 7, seeking amendment, under order 6 rule 17, seeking amendment of the amendment of the pleading, amendment of the cause of pleadings, particularly the cause of action, to say that the cause of action arose for filing the petition the day when the FIR was registered. The court has allowed the application on the ground that already the pleadings are on record earlier. As such, no prejudice would be caused to the petitioner, to the wife, and allowed the application. Agreed thereby, the wife is before this court. Next para. Land counsel appearing for the wife submits that to fill up the latches, the present application is filed as the cause of action as stated earlier does not disclose the correct cause of action. As such, the present application is filed. It is submitted that during the course of the cross-examination, the petitioner wife could elicit from the respondent husband that he has filed the criminal case as the wife has not accepted further divorce. It is submitted that the cause of action cannot be altered at this stage, and the earlier IA that is allowed on 22/9/2018, where the court has permitted the respondent to bring all the facts pertaining to FIR and other aspects, cannot be the ground to amend the present to amend the cause of action. It is submitted that the court, without any basis, has allowed this application and the order impugned needs to be set aside. Next para. Land counsel appearing for the respondent husband submits that all the facts pertaining to the FIR and other things were brought on record on 22/9/2018 itself. The husband, the wife, the petitioner wife has no complaint, and that order had retained finality. At this stage, it is not open for the petitioner wife to raise all these grounds. It is submitted that the amendment of pleadings has to be allowed, and the court has rightly observed that no prejudice would be caused to the petitioner wife as the facts are already on record, and only by virtue of this amendment, petitioner, the respondent husband, wants to amend the cause of action. It is submitted that there are no grounds to interfere with the well-considered order passed by the court, and the writ petition has to be dismissed. Anything else to be recorded?
Further, my lord, subsequent cause of action can be included because, my lord, if it is causes multiple
It is submitted
proceedings.
that even a subsequent action would be can be the cause of action, and the court was right in allowing the application.
Because it will lead to the multiple proceedings in future, my lord.
Otherwise, it would lead to multiple proceedings. Next part. Having heard the counsels on either side, produce the material on record. The husband has filed the MC seeking divorce on the ground of cruelty. Then that's in the year 2017. In the year 2018, who has given the complaint? Husband has given the
Husband has
complaint
given.
against the wife. Then those facts he wants to place on record. Then he files an application under Order 6 Rule 17 in the year 18. That application was allowed, and all those facts were brought on record. Now the matter is posted for arguments. At that stage, the present
On 27/3/2024, my lords.
27/3/2024, the matter was posted for arguments. Then on what date?
IA, my lords. On 5/8/2024, my lords.
On 5/8/2024, the present application is filed where they want to amend the cause of action. According to the learned counsel for the petitioner, as the wife could elicit that this complaint is filed only as the wife has failed to, as the wife has not accepted for the divorce, and there is no specific cause of action, the present petition is filed. According to the husband, even the subsequent events would be, would form part of a cause of action, only to avoid multiplicity of proceedings. This court is not able to appreciate the submission made on behalf of the respondent husband. When he has filed a petition in the year 2017, there is a cause of action. And if the certain facts which he couldn't place on record, if those facts are brought on record, that's altogether a different issue. But the cause of action for filing the MC as on 2017 cannot be altered. Even assuming that in the year 2018, the petitioner has stated all the facts, after the arguments are over, and after the matter is posted for arguments, after 4 months from that day, this kind of an application cannot be allowed. And by way of these applications, the laches on the part of the husband cannot be filled. In that view of the matter, this court is of the view that the court, without considering all these facts, has allowed the IA. Accordingly, the order dated so and so is set aside.
My
The
lord.
petition is allowed.
My lord, 2017 matter, my lord. It may be disposed
Which
at a
court is this?
Family
court.
Principal family.
Bangalore.
Bangalore,
And this writ petition is of the year 2017. The MCs of the year 2017, the MC shall be disposed of as expeditiously as possible, but not later than 30th of March.
Number 33, SCA Sudhindra, for petitioner. Rottame Gowda for respondent.
The respondent in this case, Lord. The same, Lord, the same terms and conditions, let this matter be adjourned till your lordship come back. Then this matter can be considered.
What is the date of that order?
Lord,
My lord, October 2025, my lord, 17.
Lord,
The first initial arrangement.
1510, my lord.
15?
1510-2025, my lord.
15/10/2025, your lordship was pleased to pass an order. In fact, I have advised my clients to strictly comply the order. So let this matter be adjourned so that
This
further.
court has passed an order on 15/9/2025. That operative portion of the order reads thus. The same arrangement shall continue until further orders.
Please.
This matter in the month of March.
Please.
1510, my lord, not 15-9.
It is?
1510-2025.
I said 15/10 or
15/10 only.
15-9 is what I thought, my lord.
15/10.
15/10. Let me just locate it.
15/10.
Please.
Yes.
Yes.
Please.
Next.
Number 34. Number 34.
I appeal for the respondent, my lords.
I appeal
for the petitioner, please.
Yes.
This matter was heard, my lord, and your lordship had indicated, my lord, the maintenance was given to wife and daughter, my lord. Your lordship had indicated that so far as wife is concerned, my case is that there is suppression of fact about her income. And I have produced certain document to show the suppression of facts, my lord, about her income. Your lordship had indicated that maintenance for wife would be set aside and it would be remanded back to the family court for reconsideration of the wife's maintenance. So far as the daughter's maintenance is concerned, your lordship had directed me to pay at the rate of 15,000. 20,000 was granted by the trial court. 15,000, my lord. I am paying it, my lord, continuously, my lord. Till December, I have
Submissions to make, my lords. The court had ordered for 10,000 to the respondent and 20,000 to the daughter, my lords. My lords, if I kindly take your lords to page number 102, my lords.
Please
My
understand.
lords,
Order is 20,000.
please, my lords.
Now, I don't remember what has.
Well, let's let
but
that-
He
let-
says it is 15,000 for both the children. And as
One
far as the
child,
wife,
one child, my lords. Only one child.
15,000 for her.
Yes, my lords.
And as far as the wife is concerned, the court wants to remand the matter.
Please, my lords, let that be reconsidered, my lords. I have one submission to make. Kindly take your page to 102, my lords.
What is the income of the husband?
Well, it's more than 1.5 lakh, my lords.
What
They
is the
have-
husband of the income of the husband?
My lord, 94,000.
Lords, that has been,
94,000 I have stated, my lord, 94,000 I have stated.
94,000. No. What is the age of the child?
my lords, as of now, it is 14, my lords, 13 to 14.
14 years.
Yes, please.
What are the school educational expenses?
Yes, my lords, it is around 1,20,000 per month, my lord, per year, my lords.
1,20,000.
20,000. If my, kindly take it to page 102, my lords, where the petitioner himself has stated that he has been paying 1,20,000 per year from 2016 to 18. That is before the institution of the very petition, my lords.
1 minute. What is the wife's salary?
My lords, as of now, she is not working, my lords. Let that be reconsidered, my lords. I'll produce that.
Why the court?
Only 1 year she had
One
worked.
submission.
It was not.
My lord, one submission, my lord. My lord, kindly look into the document by my learned friend, my lord, along with a memo, my lord, on 37.
1 minute. So now per month her educational expenses itself would be 10,000
Please,
to the
my lords.
daughter.
Yes, my lords.
Mr. Counsel,
Please, my lord.
10,000 would be the educational expenses per month to the daughter.
Please, my lord. That is what it is stated, my lord.
That is one. That is one. Then apart from the educational expenses, what about her other expenses?
My lords, in 102, it is he is itself, he has clearly stated more than 120,000 he has been paying before 2018. He has clearly stated in 4B, my lords, please take it to
How
lords.
much is paying?
He is paying, my lords, 1,20,000 per year to the tuition fees. Apart from it, he is paying medical insurance 20,000 per year and
That
transportation per year
I-
30,000. Transportation per year.
Yes, Mr.
My lord, that the insurance I am paying right now, my lord, even today, my lord. Kindly take page number 100, my lord.
We'll do something like this. Now, you pay the educational expenses of the child, entire whatever are the educational expenses, and apart from the educational expenses, how much you are ready to pay?
My lord, kindly see page number 100, my lord. My salary is 94,000, my lord. Earlier, when I was paying 1,20,000, my lord, I was employed as a dean of a college, my lord, in Maharashtra.
Let's accept that your salary is 94,000.
Please, my lord, kindly see page number 100, my lord. I have a aged mother. My expenses are 63,000 rupees, my lord. I have narrated my expenses. I am living in a rented premises. My lord, kindly take the document produced
So
by
you're left with another 30,000.
My lord,
You're left with another 30,000.
I am left only with another 30,000, 63,000.
We'll do one thing. Whatever 20,000 you're paying, let it be paid to the daughter.
My lord, kindly see the document produced by my land friend. My
In
lord,
that
why
case,
my case is,
what
my lord,
we'll do is, please listen to the court.
kindly-
In that case, we will not remand the matter. We'll say that the wife is not entitled to pay to the daughter.
My lords,
Please, my lord.
my lords, I strongly object, my lords. My lords, she is under medication, my lords. That I'll prove with the documents before the trial court.
We'll see in the month of March. This is March.
My lords, one more submission, my lords. He has not paid the maintenance to the
You are at liberty to file the execution.
Number 35.
stay is granted. That may be vacant.
Land counsel for the petitioner submits
Lord, one
that.
submission,
As
my lord.
per-
As per the interim
Counsel
direction
for
of
the
the Honorable-
respondent submits that as per the order passed by this court, the petitioner is not paying the maintenance.
Still, there is a pending of more than 45,000 rupees.
As per the order of this court, if he is not paying the maintenance, the petitioner is at liberty to, the respondent is at liberty to execute the order.
Please, my lords.
Number 35.
Kindly, my lord, kindly also record my statement that I have paid, my lord, till December.
According to the petitioner, he has paid the money. Yes.
Number 35.
I
For
appear
the
for
petitioner?
respondent wife. My lord's connected matter challenged by the wife, like the same orders being challenged by the wife in a connected petition. If it may be clubbed and heard together, my lords.
My lord, it's a very small issue, very small issue. The child is living,
That the connected matter is.
I will not object, only one submission. Child is living in a very toxic atmosphere. School, she is not sending. She's taken and run away to Dubai. I have filed habeas corpus. I got the child back.
No,
It's
no.
studying in the
Yes.
problem is, my lord.
There is a full bench matter in the afternoon. It will be continued. This another. There are four, 5 sittings are there. So I'll be coming to Bangalore. Along with that, list this matter along with so and so on next date when the bench is when the court is at Bangalore. I think it will be in the next week or a week thereafter. So they'll take it up that way.
Maybe stated as next week, before your lordship only.
And that's what I'm saying. Along with that, next week.
Obligation.
Shall pass over matter?
31.
Huh?
31.
30, what happened?
31.
31 urgent, 2 weeks. Cell number, pass over matter, cell number 15.
My lord, kindly permit.
I take that. So, diary number 331 of 2025
They
is
filed
filed questioning the
After
section
this-
14 order.
My lord, possession with the petitioner only, my lord. Possession with petitioner only,
No,
not
order
to dispose
questioning
of.
section 14.
Oh.
Then interim order
Bank
granted
and
on 5/12/2025 to deposit to how much? 1 crore.
1 crore.
On or before
That interim
30/12/2025.
order they challenged
Subsequently
and
charged
filed
with
on
the
writ
interim
petition.
order. Yes. The present writ petition is filed.
My lord, in the DRT, they have mentioned bank not to dispose of the scheduled property.
The writ petition is filed, seeking the following prayer. There is no representation on behalf of the petitioner. Learned counsel appearing for the respondent bank submits that questioning the order that is passed by the 30th Additional Chief Metropolitan Magistrate at Bangalore, dated 21/8/2025, the petitioner has approached the DRT by approached the DRT that is numbered as diary number 331 of 2025. It is submitted that in that an interim order was granted on 5/12/2025 to deposit an amount of rupees 1 crore on or before 30/12/2025. Challenging the very same order, challenging the said order of the DRT, he has filed WP number
246 of
2026. What happened to that?
Yesterday the matter was listed, my lord. The matter got disposed. They filed a 25 lakhs DD for bank.
So that was disposed of, directing them to pay 25 lakhs.
25 lakhs they paid, and 1 week granted for.
It's pending here.
No, my lord, it's disposed. 1 week, yesterday it got disposed. 1 week time they granted to comply that interim order of DRT.
It is submitted that that writ petition is disposed of on 8/1/2026, and the court has granted a week's time to comply with the interim order passed by the DRT. Next para. In the light of the fact that already the order passed by the magistrate is questioned before the DRT, and already DRT has passed an order, nothing survives for consideration in this petition. Accordingly, dismissed as infractious, giving liberty to the petitioner to pursue the matter pending before the DRT. Done?
Along with number and put here. Number. Sir, on to step next. Take next.
Other petition number 246 ಅಂತಾನೆ ಹಾಕಿದ್ದಾರೆ. ಇಲ್ಲ ಸರ್.
246 of 26.
ಅಲ್ಲ ಮ್ಯಾಮ್ ಅಲ್ಲಿ ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ ಕರೆಕ್ಟ್ ಆಗಿದೆಯಾ ಅಂತ. ಇಲ್ಲ ಓಕೆ.
246 of 26 ಆರ್ಡರ್ ಹೇಳಿದ್ದಾರೆ. ಅದು WP ನಂಬರ್ 246 of 26 ಅಲ್ವಾ? ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅನ್ನಿ. ಆಮೇಲೆ ಅಕಸ್ಮಾತ್ ಮೇಡಮ್ ಸಿಟ್ಟಿಂಗ್ ಕೂತ್ಕೊಂಡ್ರೆ ಆಗ್ತದೆ.